from the Sunshine State, this is Tampa Bay's 10 Talk.
It's time for FLALAW, brought to you by the personal injury attorneys of Perenich, Caulfield, Avril Noyes. This hour will be informative, along with taking your questions and comments. Now, here are your hosts for today's show.
Good evening. It is Tuesday at 5 o'clock. Even though the time changed, it is bright out there, but it is 5 o'clock on Tuesday. And my name is Matthew Noyes, and I'm one of the attorneys at the law firm of Perenich, Caulfield, Avril Noyes, a personal injury law firm here in Clearwater that presents FLALAW on the radio. It's a live legal call-in talk show. We're here to answer your questions regarding the law. Perenich, Caulfield, Avril Noyes has been around since 1955. We are the oldest personal injury law firm in Tampa Bay. And so one way to say thank you to the community for all their trust is to come here every week from 5 until 6 and to be available to answer any questions that you have. As you heard, we are a personal injury law firm. So I'm here to talk about personal injury, car accidents, slip and falls, trip and falls, workers' comp, and even Social Security disability benefits. But I'm not here by myself. I have my good friend and return guest, Tony Damianakis, here with me. Tony, thank you very much for joining us again today. I appreciate it.
Nice to see you, Matt. Thanks.
Before the show, we were talking about our lives, and you got a much busier life than I have, so I appreciate you taking an hour out of your time for me, but also for our listeners.
My pleasure.
So before we get started, why don't you tell the listeners, a little bit about your practice areas and what areas that we can help those listeners on today.
Sure. I've been practicing since 1993. So I guess that puts us at 33 years.
That's pretty good.
And I'm licensed in New York and Florida. I'm a partner in the firm of Peacock, Gaffney, and Damianakis, a law firm that's been in Clearwater for almost as long as you guys.
Yeah, you guys have been right down the street from us for a long time.
So Ray Peacock of late memory started it, and Patrick Gaffney took the torch, and we joined together in 2006. So I've been there for 20 years. I practice in real estate, commercial business matters, estate planning, and litigation, including trust and probate litigation. The best thing I like to tell people is the earlier someone calls a lawyer, the more options they usually will have.
That's true. That is true. Why don't you tell, I know you've had decades of experience, you've done a lot, but can you tell us what early case or what early experience made you want to become a lawyer and do the areas of law that you do?
Well, my motivation for going into law was to serve in politics and public service. So public service can take many forms, right? One way was to be a politician. I actually got out of law school and ran for office. I was elected to the school board of Westbury.
All right.
And served a 3-year term. I was single at the time, living in New York. My dad had become disabled with emphysema, so they moved to Florida in 94, and I came eventually in 97. So when in politics, you have to know people, right? So when I came to Florida, I didn't know anyone and had to start that process again. Yeah. Then I got married and had kids, and my desires to be in politics and away from the home were shelved. I wanted to be home and raise the kids, which thankfully I made the right choice. But public service has always been important to me, so I've tried to pivot politics into serving people through the law and my private engagements with the St. Vincent de Paul Soup Kitchen, the Arc of Tampa Bay, helping people with disabilities, and my church life.
Right. And I don't know this answer, but I think I probably know the answer. You feel much more rewarding doing what you're doing, even though it is a form of politics. It's given back to society. I think you really everything you do is more beneficial than if you were actually running for politics and doing all that stuff that they have to do.
Yeah, I agree. I'm afraid that our system is broken, and I'm not sure what they are achieving or can achieve at this point where there's such stalemate. Nobody talks to each other anymore. Nobody looks for long-term planning. It's all about what you can get today and what deal you can make today. And it's a great tragedy because we are in a beautiful country, and we are watching it decline right in front of us. I think all of us, regardless of political persuasion, realize the problems we're having here.
Right.
Corruption is setting in.
Corruption. And it seems like they spend a little time doing their job, and then they spend a lot of time trying to get reelected.
Yep.
And I want to stay out of politics the best that I can. But that's what it's like, let's just get our job done. If you and I took on a case and we worked just a little bit on the case and then said, okay, now I'm going to focus all my energy on getting that new case and ignore this case, I think we wouldn't be having clients for too long.
Both your firm and ours relies solely on reputation. I don't market myself. I don't advertise. I don't have a billboard. And you have even more difficult with all the billboards and personal injury. You guys are more heavily reliant on your years of good reputation. And that's what gets us, enables us to do what we do.
That's right.
Yeah.
That's good. So listeners, that's Tony Damianakis. I'm Matt Noyes. We are here live for you. We're going to talk about, just about any areas of law. Tony does so many areas of law, and I can tackle on a few of them as well. And even if we don't do that area of law, we'll be happy to at least address your concern and take your information and guide you to somebody that may be able to help you tomorrow or the next day. So how do you get in touch with us? How do you get your question over to us? Well, there's 3 ways to do it. One way is by giving us a call, and that is at 727-441-3000. It's a live call show. So give us a call, get on the phone lines while they're still open, and let us address the questions that you have. Another way to do it, so I hope, is through our Facebook Live page. I see the little wheel spinning saying live video is starting, but it has not yet started. But when it does, you can jump on our Facebook Live page, and it's the firm's Facebook page at Perenich, Caulfield, Avril Noyes Injury Lawyers. And you can just type in your questions right there. And there's yet a third way. And the third way is our YouTube page. Just jump on our YouTube page. And again, that's Perenich, Caulfield, Avril Noyes Injury Lawyers. And then on the other side of the glass, will let us know what your comment is, and we'll be able to address that too. So 3 ways to do it. 1, the easiest way, 727-441-3000. And I think if I refresh Facebook, maybe that will work. And if not, then the YouTube channel at Perenich, Caulfield, Avril Noyes Injury Lawyers as well. So this is the time to jump on the phone lines, and so we can address the questions that you have. Tony, one question. I know last time we spent a lot of time talking about your probate practice and stuff like that. I want to really focus a little bit more on your real estate practice, and because a lot of people make mistakes with their home. Can you tell our listeners what's the biggest legal mistake people can make with their home, whether it's purchasing it or selling it or titling it and such like that?
So if you're buying something, I always recommend to people get an attorney. There's so many things to review, and they can guide you through the process and protect you. The title of your home needs to be clean. What
does that mean?
It means there can be liens on it. There can be fines. There can be unexpected lawsuits or claims of other people who think they own it, especially in cases where people inherit properties, never did the probate, and then you trying to buy it, and you're going to find out that your closing is going to be delayed. So the review of a title commitment from a reputable title insurance company is really important. An experienced real estate lawyer will know what to look for when you're buying property. Get a survey. It's unless it's a condominium or something. But if it's a home, I tell my clients, get a survey. Know where your lot is. Know whose fence is on it. Know whose shed's on it.
That's important,
know
right?
whose driveway's on it before you do the closing, so you know what you're getting into. at the closing table, there's all kinds of charges these days. People try to take advantage of unsuspecting buyers.
Really?
And you need to know what you're being charged, if it's reasonable and customary in the area that you are closing. HOAs, you need to know, was there an assessment coming down the road? Or, you order an estoppel. What's your monthly HOA fee? Is it set to increase?
Are they required to tell you that before you purchase the home?
They are, but you have to ask.
Oh, okay.
You have to ask for that estoppel.
All right.
If you're, if you don't have a competent title insurance company, you may be surprised post-closing. Condominium restrictions, declaration covenants preventing you, if you're a painter or a small business and you want to park your work truck in the driveway, you may be disappointed to discover that your community doesn't allow commercial vehicles to be parked in the house.
Right.
So things that, a real estate lawyer is not expensive. You pay for an hour or two of their time. They'll get you through the transaction. It's a wise decision.
Right. You pay for it now, so you don't have to pay 10 times more later.
A thing we see a lot these days is there's been a proliferation of Johnson v. Davis cases. These are cases where buyers buy property and then try to blame the seller for not disclosing latent defects. What I mean by latent is a defect that's not readily visible, but the seller should have knew or should have known. So sometimes, you get the classic example of a seller painting the ceiling and putting some bubble gum on the roof leak, getting through the closing, and you discover that you have a shoe-size hole in your roof that leaks on the first rainstorm after your closing.
Yeah.
That seller knew or should have known about the leak, and he did not disclose it. That's actionable. On the other hand, you'll have buyers who get in there and realize, oh, you know what? This bathroom's old. We sure could use a renovation. And I'll try to blame the seller for the bathroom pipe that was leaking or whatever. And they have no merit, but they'll bring a Johnson v. Davis claim against the seller. So I've seen sellers wrongfully sued, and I've seen buyers bring actions that they really needed to bring for sellers that wronged them.
Right. And if either one of them had the attorney, that suit could have been avoided by doing the proper inspections and such.
You are always counseled to do your home inspections, or if it's commercial property, your visual and expert inspections. If the seller's shrewd and sophisticated, they will hide it, right? So sometimes you won't discover it.
Right.
But they will pay for it if you have the right attorney on the back end.
That's why it's so important. I think that is so important. And you talked a little bit about, when people inherit the home from their parents who may pass away. Sometimes they just move right on in and they take over the home because they inherited the home, but the process didn't go the right way. What problems arise in those situations?
So a lot of times you'll have, let's say you have 3 siblings. One is either living in there, like you said, or takes charge of the situation. He'll go out, he or she will enter into a contract with you. You're thinking, okay, I'm buying this house. And you'll discover after your loan application goes through, when you're ready to close, you're getting ready to move out of wherever you're getting ready to move out of. A lot of pieces involved that the guy who told you he's the owner really doesn't own it by himself. There's 2 other siblings. And that late mom never really probated the estate.
Mm-hmm.
So you either stuck waiting for them to probate it, or you're going to lose your loan commitment, your interest rate's going to go up, or you're moving trucks waiting on your existing home. A lot of things can go sour. That's where you would pick up on a probate problem early on in the real estate transaction upon reviewing a title commitment.
Okay.
The title commitment will tell you this house used to be owned by a deceased person and there's been no probate.
And sometimes the kids, they're not doing it maliciously. They just think that,
Didn't know.
yeah, they just take over. Yeah,
Yeah,
mom and dad gave it to me. And
Mom told me we were getting the house.
Yeah.
That's not a dispute.
right.
I have a will.
Yeah.
It says so. Yes. But when you have a will, you have to bring it down to the probate court, file it, and then you have to probate it. That means the judge is going to say, yes, this is a valid will. Yes, this person is in charge of implementing the terms of it. That's called the personal representative, or up north, it's an executor.
Right.
After that paperwork happens, someone will be authorized to sell the house, but not before.
And I think that's where your expertise in probate and in real estate really can intersect with each other.
Yeah.
And your clients benefit from that mutual knowledge of both of those areas of law. I think that's a wonderful thing to do. So that's great.
Yeah.
You listen to Tony Damianakis. I'm Matthew Noyes. I'm with the law firm of Perenich, Caulfield, Avril Noyes. I do finally have Facebook Live running now, so that's a good thing. And so if you are listening and you want to see us in the studio, just jump on our live Facebook page at Perenich, Caulfield, Avril, and Noyes Injury Lawyers, and you'll see us, and you can type your comments in there as well. Or if you have a question, whether it's regarding real estate, buying or selling a piece of property, whether it's residential or commercial, because Tony, you do both, right? Whether it's that or probate or personal injury or other matters that we're going to be talking about, jump on the phone, give us a call at 727-441-3000. We are live here until 6 o'clock. And so let's be available to you to answer the questions that you may have. Tony, before we take the first call, we kind of touch base on estate planning and probate and such like that. Why can you tell our listeners why everyone needs to have an estate planning and not just the ones that have money or that have assets and
Sure.
such like that?
So you don't need to be a wealthy person to have an estate plan. If you own a home or have children, you need to plan, especially if you have young children. You need to have a plan. If they're older and there's pretty straightforward distribution, you still need a plan of who's going to handle the necessary paperwork to make it happen the way you want it to happen. Estate planning isn't about death. It's about making life easier for the people who you leave behind.
That's important. I think that's what people don't fully appreciate. They say, well, I don't want to talk about it because I don't want to talk about my death. Well, you're really not. You're talking about protecting those you leave behind. So I think that's important.
Yeah, the traditional way of planning is a will. A will will work just the way you want it to if it's done by a licensed attorney and competent attorney. It says what I want to happen when I die and who's in charge of doing it. The downside to a will is that there's probate involved. It has to be probated, and there's a cost to the probate. As I said earlier, probate means you bring the will down to the courthouse, the judge has to approve it, and authorize the person in charge to do what they have to do. Typically, you can expect a cost of about 3% of the value of that estate.
Okay.
So that can add up if you have a sizable estate.
Sure.
Even $100,000, typical house, that's a $3,000 expense.
And that expense is not just the attorney's fees, but it's also the personal representative can charge 3% as well.
On top of that, So now you're talking $6,000 on a simple $100,000 case.
Okay.
Right?
Yeah.
There's ways to avoid that. And we counsel our clients, depending on the circumstances and the assets that they have, how to avoid that and how to make it easy and private. The very common way to do that is a revocable living trust.
And I think private is a very important adjective because the will everybody can see. I mean, Elvis filed his will and everybody got to see his will because it was filed with the court.
It's true. If privacy is a concern, you don't want to probate.
Right.
You want to do a living trust where no one knows and no one has a right to know except the beneficiaries of those trusts.
Right.
A beneficiary has a right to see what's the copy of the trust. And the way the trust works is just like a will, you set forth your wishes. I want this to happen and I want this person to do it. And it'll happen. The only difference is there's no court involved. You, depending on who you name as trustee, if it's a family member or not, they may get a trustee fee. But most of the time, people either put one of their beneficiaries and they're asked not to get a fee.
Right.
And that normally that's how it goes.
And just like the will, the trust, it doesn't kick in, so to speak, until the person passes away.
Great point. So during your life, you are in charge of that trust. You are called the trustee. You can buy stuff, you can sell stuff, you can
have access to all the bank accounts. It's not like you're tying all the assets up. You can't sell your house because you put it in a trust. That's not the case, right?
Absolutely not. You're 100% in charge, just like you are in your individual capacity. The trust provides that when you die or become incapacitated, and that means unable to do your reasonable functions, and 2 doctors have to certify in medical certainty that you're incapacitated. It's not just someone saying, Dad's having a senior moment.
Right.
You have to have doctors certify your incapacity. Then your trust will provide who's going to be the successor trustee. Who's next?
Okay.
And you can put your spouse, you can put your trusted children,
right,
or anyone
right,
that you feel is competent enough to get it done.
So trust can come into play before you pass away, but you lose competency.
Yeah.
That's not the same with the will, though, correct?
A will does not work until you die.
Okay.
Yeah.
What can some people do to protect their family, if they don't have a trust, but they still want to protect the family and peace of mind for the family, should they become incapacitated?
So one of the most effective tools we recommend is something called a power of attorney. And in that power of attorney, you will have a designated medical healthcare surrogate, someone who can make medical decisions for you. And you will also designate someone to be your financial agent, someone who can do your financial transactions.
Okay.
Typically, you can have, that's the same person.
Right.
Husband and wife will name each other, and then they'll name a backup if they die. Normally, one of the kids who they trust to be responsible. They can name more 2 kids if they like. So they have to work together. That power of attorney works while you're alive. So if you're incapacitated, they can go down to the bank, pay your mortgage, pay the taxes, and pay your doctors, and deal with your doctors.
But it can also have a double-edged sword, so to speak. It works while you're alive, even if you're not incapacitated. Is that correct?
It's true. And also, it's such a strong document that I tell people, whatever you can do with a pen, your agent can do with a pen.
Right.
Meaning they can clean out your clock. They can go down to the bank and take the money, no questions asked. I make them sign a disclosure that I have advised them of this.
Right.
And you better know who you're giving this document to.
Right.
Normally, it works fine.
Sure.
I, of course, have seen cases. I always get the call from someone that says, my sister took all my mom's assets before she died. She had a power of attorney.
Right.
And I'd say, well, where were you? Well, we didn't really talk. I said, well, it's kind of late now.
Right. Yes.
You have
because if she did, in fact, have that power of attorney and she did transfer all the assets to herself, she didn't do anything criminally wrong.
It's not criminal unless you really got to go have extenuating circumstances. And it's really a hard uphill battle if trying to explain people's thoughts and intentions after the fact.
Now, is it your practice not to give the person with the power of attorney the actual document?
I don't. I leave it up to the client.
Okay.
Yeah.
That would make sense. I would think.
I always recommend, you don't have to give it to them. You let them know it exists. Let them know where it's kept.
Right.
God forbid you get sick.
Right. I think that's a good idea.
Yeah.
Is there other forms or documents that are beneficial as part of the estate planning besides a will or a trust and the power of attorney?
we also do something called a living will. And this comes out of the famous Terry Schiavo case. It existed before that case, but people have become aware of end-of-life issues.
And that happened right here in Clearwater.
Yeah.
Yeah.
So a living will say you don't want to be kept around on a machine and artificially prolong your life if, and this is important, and only if it is a medical certainty that you're not coming out of this. And they actually define the medical conditions.
Oh, okay.
In the form. So it's not just a matter of, you had a bad run, your kidney's failing, and you're in ICU, and chalk it up, you're done. No.
Yeah.
These conditions are more like you're brain dead, and there's no medical way you're coming out of it. And so the only thing a machine's doing is feeding you and breathe and letting you breathe.
Right.
And if you unplug the machine, it is certain that you will die. As opposed to ICU, you're in the hands of God and the doctors.
Right. And so that living will does what? What does it do? It
tells your wishes. It says, I don't want to be a vegetable. I don't want to be on a machine artificially. And what it really, most of the time, those decisions come naturally. A husband and wife can make those decisions without a living will. They do it because they're in charge.
Right.
Where it comes in handy that I tell people is with the kids. You'll have 4 siblings. You'll have 3 that say it's time for mom to go. And you'll have the one that just can't let go.
Right.
We all know that scenario.
Sure.
And it's understandable. It's not wrong. It's just emotionally too hard for them to say no.
Right.
Let go. The living will can be shown to that sibling and say, look,
this is what
this
mom
is
wanted.
Mom's wishes.
Yeah.
And it's legally binding, and it will prevent family, or it could ease family tensions and arguments.
And that's why the estate plan is so important, I think. I mean, it really watches out for the family, gives peace of mind to the family, and also protection, asset protection to the family as well, even after they pass away. I think the Schiavo case had to do, we talk about the 4 children, and the one child may want to keep mom alive, but it's also could be a spouse and the parents of the person that's incapacitated. So I think those documents are so important because it helps those people that are already suffering with guidance. They know, okay, this is what Susie would want me to do. This is what I'm told I'm supposed to do. Even if I don't agree with it, this is her wishes, and so we have to do it.
The path is set forth.
Yeah, so estate planning is so important, and estate plan is so important for really anybody, for whether they're wealthy, not wealthy. We all are going to die. And so I think it's important that there's at least some kind of planning going on. That's why you are here to help those people. So we appreciate all you do. And I'm sure the families really appreciate the comfort level that you provided at a very sad time in their family's life. So listeners, if you're just tuning in, you are listening to FLALAW on the radio. I am Matthew Noyes, one of the partners at the law firm of Perenich, Caulfield, Avril Noyes. We are the oldest personal injury law firm here in Tampa Bay. We have been helping people since 1955. And for the last about 2 years, we have been presenting FLALAW on the radio. This is a live legal call-in talk show. We used to have a live TV show called FLALAW, and then they got rid of live TV for some reason. But so we have brought it back on FLALAW on the radio, here to give answers to questions that you may have regarding our areas of law, but also our friends and colleagues' areas of law as well. And tonight I have Tony Damianakis here, and he's here to answer questions regarding probate, real estate, business law, and other types of law that you may have. So 3 ways to do it. Give us a call, 727-441-3000, or jump on our Facebook Live page at Perenich, Caulfield, Avril Noyes Injury Lawyers, or you can jump on our YouTube page, same name, Perenich, Caulfield, Avril Noyes Injury Lawyers, and type in your comments there, and we'll be happy to tackle it or address the questions that you have. Even if you don't have a question, just have a comment, please feel free. I mean, that's one thing that we enjoy about our practice, is that we are able to have a discussion about what's right about the law, what could be changed about the law. I still think we have the best set of laws in the whole world. It's not perfect, but we have the right to complain about them, and we have a right to enforce them, and we have a right to change them. And so I think commenting and talking about it is very important. So, and before I forget, because I told Ed that I would keep the listeners updated on the e-bike legislation. And last week we were talking with the creator of Eye on Tampa Bay, who posts almost immediately car accidents and information. And just this week, I think it was yesterday, the House passed the e-bike legislation as well. So Senate passed it. The House has passed it. It's going to go up to the governor, and we're going to see if anything's really going to happen with e-bikes. Unfortunately, the law says, well, we're going to get a task force and we're going to talk about it. But at least they have a deadline, I think October 31st, to give us their opinions. And there will be a law saying that you have to have an audible sound when you're coming close to somebody on the sidewalk, and you have to slow down to 10 miles an hour. So there is some legislation. It's not the best legislation, just like we were talking about, but it is an opportunity for some change. And that's what I love about being part of the law, is that we get to voice our concerns, and we can sometimes see actions change because of the concerns that we have. And I think that's not just in personal injury and e-bike accidents and car accidents, but it's in probate and it's in business relationships. And I think, Tony, you have probably witnessed the best and the worst of business partnerships. Yeah. It looked great in the beginning, two friends, hey, let's start a business together. And life happens and things happen and they're just not friends anymore. So can you tell us why or how, what situations result that, a handshake deal with your buddy, let's start this up, can often turn into litigation or lawsuits?
I see a lot of it.
Sadly, yeah. I hear about it a lot.
Two folks decide to start a business. They both will invest a significant amount of money in the business. They'll get started. And they soon find out that either they have different philosophies, or one of them is not carrying the weight, or one of them doesn't want to pay their appropriate contributions. But they're 50-50, which means no one has a controlling vote.
Right.
And so you'll find a deadlock. And deadlock is a basis for dissolution in Florida. Dissolution means you want to dissolve the company because you have no choice.
Right. Can't make any movement.
Yeah. And it's a terrible outcome. More often than not, two partners will both suffer in that scenario, because what it does is you go to court, you say we have a deadlock, stalemate, and we have to dissolve the company. And the judge will say, okay, well, we're going to sell the stuff on the auction block.
Right. On Facebook Marketplace or something like that,
So for example, I'll use a thriving radio station, right? A radio station has equipment, but the value of the radio station is its goodwill, its advertising. If there was two partners that didn't see eye to eye and they had to close that business, all of those customers, the advertisers, the shows like this, they go away. And the only thing the partners would get is the auction on used computers and used microphones.
Right.
That's how much of a disaster. Obviously, it would wake up the partners, hopefully.
Right.
And they would go and say, all right, if we're going to close it, at least let's try and list it and sell it on the open market.
Okay.
But even their things become so bitter that one partner won't see the rationality of even
I don't
that.
want anything to do with you. So I'm not even going to do that.
We're not even going to cooperate so we can maximize our return. So if, for example, you both spent $70,000 to buy this beautiful studio that we're in and renovate it and get all the sophisticated equipment, and then you find out your partner and you don't get along, and it has to be shut down and sold, and not going to get back your 70, in that scenario.
And a lot of times those businesses start, as you said, on a handshake and nothing in writing. How can something in writing prevent those problems from happening?
It defines what happens when there's a dispute.
Okay.
Like you can set forth rules. You can give each other rights to purchase the other and at fair market value. So both sides can be protected.
And this is like through a partnership agreement?
It can be a partnership agreement. It can be an operating agreement if it's an LLC. It can be a shareholder agreement if it's a corporation. So each of the entities have their own specific form, but it's basically the same idea.
Way. Okay.
Taking that handshake and laying it out on a piece of paper goes a long way.
I can imagine.
Yeah.
Because when you're just starting the business, you're very good friends. You just think it's going to succeed wonderfully. Everything's going to be just rainbows and unicorns, and then life happens and challenges happen, and sometimes the business just starts to dissolve or differences occur. But I think what also may occur is one of the partners may pass away. And what happens when that happens? If there is no agreement?
You can actually set forth a succession plan in those agreements, either the partnership, operating, or shareholder. And that succession plan will protect your family. That's another form of estate planning. What happens to my shares in my business? How is my wife or husband going to get paid? How will my kids be protected? And the surviving shareholder is obligated to follow the rules of that purchase. So they'll have the right to purchase the decedent's shares at a reasonable fair market value. And you can set forth how it's to be paid. You can set forth a specific amount that's to be paid if you can do that. But the most dangerous words in business are, we don't need a written agreement.
Right.
Right.
Yeah,
We trust each other.
Yeah.
You do trust each other, but life happens.
That's exactly true. That is exactly true. And that's just another example of how your experience in probate and in this situation, business law, how those can intersect with each other and help protect both on the probate side and the estate planning side, and also on the business side as well. And again, it is to prevent fighting later on. And I think it's so important in your job is you're able to do that. In my job, we sometimes have to fight because a bad thing happens, and we have to sometimes litigate, most times litigate about causation, liability, and also the damages that occur. And so we oftentimes have to kind of duke it out, and there's no other way of doing it. But in estate planning, in real estate, and in business, there's ways to prevent having to go into litigation. But the only way to do that is to contact somebody like you, though, right?
Yeah, and we pride ourselves on helping. Sometimes I'm too successful at it, talking people out of different things.
Yeah.
But I could sleep at night.
Right.
So you tell them the truth. You tell them ways to avoid it. There are ways, for example, to do an estate plan where you don't need a trust and you don't need a will.
Can you give us just a general idea about what that is? I know there's a few different ways to do that.
Yeah, there's a lot of scenarios where people basically have a house, a checking and savings account, maybe some investments in IRA and a 401k. Very typical scenario. So to handle the real estate, there's something called an enhanced life estate deed. You can provide that you and your wife will have the right to live in that house for the rest of your life. You'll have the right to sell it if you choose without anybody's permission. But when you die, oh, by the way, with the life estate, you get to keep your homestead exemption. So you keep your tax break.
Right. Yeah.
But if you die, it'll go to wherever you want it to go. In typical scenario, to your children. That gets recorded and that gets done. No probate, no will, no trust. Then you can arrange bank accounts to have survivorship status, pay on death or survivorship account. Go down to the bank, you tell them, if I die, I want this account to be paid on death to whoever you choose.
Right. And that avoids probate.
That avoids probate.
Right.
So now you've
So you
taken
got
care
a
of the
house
house.
out of it and a bank account
Bank accounts
out of
are
it.
out of it. If you have a 401k, you make sure you have a beneficiary form filled out. That'll go directly to your beneficiaries. IRA, same thing. And all of a sudden, you've structured your plan so that it's all done.
That's a wonderful way to do it, to avoid at least the biggest cost of probate. You may have the paintings in your house and the furnishing and such like that, but you may not have to go through probate on there either, because I think there's a list of tangible property that they can do as well.
There is.
And that avoids probate too.
Yeah. So
that was going way back there in my probate class.
It's called a separate writing.
Okay.
Yeah. But most of the time, unless you have Picassos or very valuable things.
Right.
Now, if you have people who have significant collections of whatever, I don't advise that. I think that should be some sort of writing for that.
Sure.
But most of the time, if it's just old furniture and some pictures.
As my Chicago Cubs collection, I think neither of my kids would want it. And so they'd fight about not taking it. So, but
I'm not going to insult the Chicago Cubs because you're kind enough to invite us here today.
Yeah, so. I love my Cubbies, that's for sure. But yes. So there are ways to avoid probate, but you need to talk to an attorney about how to do that.
Yeah, you want to do it right. The enhanced life estate deed is not for the faint-hearted. There's so many mistakes. People try to do it. It's got to be done right. If you don't do it right, you won't be able to sell the house if you decide to sell the house, or you'll need the permission of the people who you decided to leave it to. I've seen huge disasters.
Oh, wow.
Legal descriptions can be made incorrectly. It can also affect, depending on your circumstances, if you want to refinance, banks don't like it. So there's things to discuss.
Okay.
But there's things that you can do.
That sounds very good. Sounds very good. We talked about business partnerships, how they can turn into being a legal disaster, but there's also real estate deals that can turn into legal disasters as well. We kind of talked a little bit about it, not doing your due diligence and the title insurance, but are there other things that could happen that could make a real estate deal just turn into a mess?
Sure. So a real estate transaction may look simple, but legally it's one of the biggest financial decisions you're ever going to make. So you really want to know what can go wrong. The obvious, buyer and seller do a contract. Seller changes their mind. You might say, well, can they do that? No, but it gets done.
Yeah.
And you got a lawsuit on your hands.
Okay.
And it's a lot of time and a lot of money in that kind of lawsuit. Fortunately, if your contract is done correctly, there should be an attorney's fee provision in it, which will entitle you to recover attorney's fees if you succeed.
You have to fight for that. Okay.
But you're fighting for that.
Right.
So, what can happen? Well, people can get funny, or buyers can change their mind, or buyers can try to swindle you into a lower price at the last minute, threatening to walk. And a seller with a good attorney knows that's just a game. And so you'll look them straight in the eye or straight in the email, and you say, no, we're not. You're bound to pay the full price here. The contract doesn't say anything about these things you're bringing up at the last minute.
Right.
So every contract, a real estate contract, has something called a due diligence period. It's a time frame that you define, 10 days, 20 days, 30 days, where the buyer can kick the tires and the buyer can, for whatever reason, walk. If that due diligence period expires, the buyer can't walk.
Okay.
They're bound. Their
Okay.
deposit comes hard. They can lose their deposit. Most of the time, that'll be the extent of their
I was
damages.
going to say they can't really
You
force
can't
them to
make them
buy
it. Yeah.
They'll make
most-
sure that their financial status prevents any bank from being able to buy it, but their deposit would be
That's
forfeited.
your insurance. So you want to get an adequate deposit.
Sure.
Sometimes people don't think much about the deposit because they think, oh, well, I can't use it anyway before the closing, so it doesn't really matter. Yes, it matters if the buyer walks or defaults.
Right.
Right.
No,
So it matters a lot.
Now, there's sometimes also that I would assume that the seller, after they enter into a contract, somebody comes to the seller and says, well, I'll pay you more. And so that contract also gives the buyer the protection too, right?
It certainly does. And then if you have a lawyer that's sophisticated, not just in the real estate transaction, but in litigation, you know there's something called a lis pendens. So you can file a quick complaint with a lis pendens that will prevent that seller from selling it to that guy. So even if someone comes to them with a bucket full of cash and they want to do it and not worry about the other buyer, they won't be able to get title insurance with that lis pendens. Lis pendens is a very powerful tool.
Oh, that's interesting. I didn't know that. That's
it has to be but you have to make sure there's merit to it.
Sure.
I had a case once about 20 years ago. It was a bunch of people in the community that had a dispute with the developer who didn't hand over 2 of the lots that were supposed to be community property. So we filed on behalf of all those folks, they tried to file a lis pendens. And in that case, I thought the judge was mistaken, but the judge didn't recognize the lis pendens and allowed the sale to go through. We were arguing, the judge and I, but at the end of the day, the judge won that one. And the folks,
they often do that sometimes.
I thought if we could appeal, we would have won. But the folks didn't want to spend a lot of money. It was an insignificant value to those properties.
Okay.
It was, to them, it was more sentimental. That's where they had their clubhouse. That's where they played their gin and their bingo. But so a lis pendens is a very sophisticated tool.
Yeah. So I think that is so important. And again, that's why litigation experience is so important as well. And the other problems that may arise with the real estate is easements, boundaries, and such like that. Isn't that right? They have to fully understand what those problems are.
That is true. You don't want to buy a piece of property and discover that the county owns half of it.
Right.
You can't put your pool where you think you were going to put your pool. You can't put your swing set or your fence because they have a drainage easement or something like that.
Yeah. So all those things, you may love the property. And I think sometimes buyers get blinded because the property is just what they were looking for, everything. And without an attorney looking out for them, they sometimes go in there blindly and make these mistakes. So when should someone call an attorney? Let's first start with in the real estate business, in the real estate transaction. When's the best time? If I'm thinking about selling or I'm thinking about buying a commercial property or even a residential property, when should I talk to somebody like you?
So if you're a seller, I tell people, go ahead and make your deal, but don't sign anything. I'll either do the contract for them, or if they have a realtor, a lot of times your realtor will generate the contract. I will review it. We have a great system in Florida. There's a form called the FAR. It stands for the Florida Association of Realtors.
Okay.
And the Florida Bar. So the realtors and the bar real estate attorneys got together years ago and came up with a form that's constantly being revised. And this year it's revised as well, that tries to make the transaction trouble-free.
They think of all the problems that could arise and they address them there.
So the minute I get that, if I see the FAR, I know what boxes to look for.
Okay.
I know what needs to be checked. I know what blanks need to be filled in. And the good thing about that for my client is it won't take me but 15 minutes to a half an hour to review that contract.
Okay.
When I do a closing, I won't even charge my client, the seller, because the closing will be fine for me to get the closing fees and the title work. So I won't even charge for the contract. So my seller clients get the real estate contract for free. They get the protection of having the deal done right, and they get to close it in my office. When you're a buyer, I tell them the same thing. Do not sign anything unless I see it. And again, it could take a 15 to 30-minute review, or it could be much more complicated if it's not the FAR bar. You'd be surprised what sellers try to work
Really?
up.
Yeah.
We live in an age of AI, and
True.
documents can be generated very easily. I would not trust an AI-generated contract if I were you.
No, you can't.
All right? So the other thing a buyer gets from our representation is just I can help them stay on top of their deadlines. If they miss certain deadlines, like the due diligence or the financing deadline, they could be in big trouble down the road.
Right, especially if the seller's trying to get out of the deal for one reason or the other. So it's important, I think, for the buyer also to contact you probably even before they submit an offer to them, because that offer could subject them to legal consequences that they don't even appreciate.
So here's a nice little tool for you. If you really want to, if you're worried about that offer that has to be made, sometimes that's true, right? Mm-hmm. Time is of the essence to not lose the deal. You can make that offer, but there's an addendum to the Florida FAR Bar called attorney review rider.
Okay.
So it'll say the offer is good, subject to my attorney's review, and it'll give your attorney 3 days to cancel the deal.
Oh, wow.
So you would fish out the seller, tie their hands, and get your lawyer to review it the same day or the next day, and you have yourself a deal. So buyers can use that attorney review. A seller can use it too, actually.
Right. No, I think that's a wonderful thing.
It's called the attorney review rider.
I think that's good.
Yeah.
And I think since we talked about real estate, also business, they should be jumping into your office and talking to you before the business even opens the door, right?
So important. Or when you're buying an existing business,
right?
One of the biggest mistakes a client can make is, well, I want to make this easy, so I'm just going to buy his business. We don't have to change anything. I'm just going to buy his shares.
Right.
9 out of 10 times I tell them, no, you're not. Oh, why not? Because you're buying their shares, but you're buying their bills. Whatever they owe and whoever they owe,
think about that.
You now owe. Mm-hmm. So if I buy ABC Corp, I buy ABC Corp's debts.
Right.
Don't do that.
Right.
You want to do what's called an asset protection agreement, where all you're buying is the tools and the toys. So if I bought this radio station, I'd buy the equipment, I'd buy the lease, or if it's owned, I'd buy the property, or I would get a lease for the property. I would do everything except buy the baggage of that prior business.
Sure. So Tony, if people want to get in touch with you, we got to wrap it up, but if people want to get in touch with you regarding all those areas of law, how can they reach out to you?
So Peacock, Gaffney, and Damianakis is located on 2348 Sunset Point Road in Clearwater. My phone number is 727-796-7774.
That's good. Yeah. Tony, I appreciate you taking the time talking to us.
A pleasure.
Listeners, thank you for listening to FLALAW on the radio. We'll be back next week. But in the meantime, drive safely and watch out for those who don't. Take care.
106.1
WDCF, Dade City.
FM 102.3.
Listen.
This is CBS News on the